notice of adjudication is the notice by which the referring party, or the claimant, notifies a responding party, the defendant, that it intends to shortly commence adjudication proceedings about dispute relating to a project. The full title of the notice is the Notice of Intention to Refer a Dispute to Adjudication. The referring party will very shortly after, or sometimes at the same time, then serve a referral notice. And this is the second notice from the referring party, which sets out in detail the facts and legal basis of their claim against the responding party. It contains the facts and legal arguments put forward by them, and it refers to all of its evidence. Service of this notice marks the commencement of the 28 days for the adjudicator to reach a decision on the claim. The response is the responding party's detailed answer to the referral notice, effectively the defence, and typically the responding party will have just 7 days to serve it from receipt of the referral notice. So you can see how you've got to be super organised and have already prepared as much as possible prior to commencement of adjudication. And that might mean, for example, following our advice on how to be prepared for an adjudication to happen. The reply is the referring party's answer to the response. It's their opportunity to essentially comment on the defence. Now, the referring party needs the permission of the adjudicator in order to submit a reply, but often they'll submit one without permission, and it's down to the adjudicator to decide whether or not they're going to take that into consideration when deciding on the dispute. The rejoinder is the responding party's response to the reply. And again, permission is needed from the adjudicator to submit this. But again, responding parties often will submit this without having such permission. And so it's down to the adjudicator to decide whether or not it's going to be considered. The surrejoinder is the referring party's response to the rejoinder. And again, same applies, that often this is submitted without the permission of the adjudicator, and it's down to the adjudicator to decide whether or not they take it into consideration when reaching a decision on the dispute.